Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. Today was day 38 of the Mass Casualty Commission proceedings, and there were four things going on today that were discussed in the proceedings that I'll cover in this video. First was a decision that was released actually on Friday afternoon dealing with some witnesses and requests for questioning and the right to cross-examine. The second and third thing were what actually took place in the proceedings today. One was a presentation from Mass Casualty Commission lawyer Emily Hill on next of kin notifications, some of the issues there, and then Constable Cst Dorrrington testified. That was sort of the bulk of the day. Presentation was short, probably about a little under half an hour. Constable Dorrington testified until late afternoon. He had a long day on the stand. Very interesting testimony. And then finally there was a announcement by Jamie Van Ward at the end of the day about the Big Stop videos, the videos from the Enfield Big Stop, which had been the subject of an application by Frank Magazine and have been finally released and are now up on the Mass Casualty Commission website. So some interesting notes on those videos, and I've reviewed the videos and give you some comments on those as well. Do that towards the end. So the first thing I want to talk about is this decision that came out on Friday afternoon. And really all you need to know about the decision in a way, other than the subject matter, is that it came out late on Friday afternoon. Whenever that happens, you know that whoever has issued that news, put that release out, doesn't want you to see it. It's something that they wish they didn't have to release, but they do have to release, and so they do it at the time when they think very few people are going to be watching. And in fact, I didn't see it. Well, I saw it when it came out, but I wasn't able to get to read it until yesterday afternoon. This was to do with two parts of sort of the same question. There was a request for Staff Sergeants Rahill and O'Brien to be recalled and subjected to cross-examination questions. You'll recall that each of those officers testified by video, recorded video, which was then played. Nobody was allowed to, they didn't have to see anybody else other than the Mass Casualty Commission lawyer who was asking them the sort of predetermined questions. And it was all very, very trauma-informed, quote-unquote, but not satisfactory to the participants. There was no cross-examination allowed. The second part of that was then a request from Tara Miller from MDW Law, representing a relative of Kristen Beaton, that lawyers be mandate, or that the rules be changed, the commission rules be changed, that instead of lawyers being possibly able to cross-examine witness, that they would have the absolute right to do so. By default, they would have the right to do so, rather than it being at the discretion of the commissioners as it is now. So the commissioners rejected both of those requests. They said just on the rules, that the rules were distributed a year ago, and nobody objected to the provision on examination of witnesses at the time. Well, that's sort of an easy thing to say in a way, because when you look at the rule, it says that participants may examine witnesses to the extent of their interest in the proceedings. Well, anybody reading that, and certainly any lawyer reading that in advance, would think, okay, well, if you're one of the participants' lawyers for the families, your interest covers every witness, and other participants may have limited interests, but the family participants are going to have an interest in every witness and should be able to thus examine every witness as long as the questions are relevant. Well, that's not the way it's turned out. There's all these forced collaboration, and sometimes the commission counsel are asking questions. So the rule has some discretion for the commissioners, and it's the exercise of that discretion that's really at issue, not the wording of the rule. So the participants sought to have that discretion removed. Commissioners rejected that, as I expected. I mentioned this in discussion when the application came out, I think a week and a half ago. Second part of what their response was, in particular with Staff Sergeants Rahill and O'Brien, was that the accommodations, they say, served their intended purpose. In other words, that the accommodations worked. They were able to, in the Commissioner's view, get the evidence from these witnesses and get, valuable information from them. Of course, we can't, that's easy to say. We heard the witness, we heard their evidence. We don't know what it would have looked like with cross-examination and all of the regular things that you expect from witnesses, with the little bit of added pressure on each of them to answer questions more thoroughly, to have their answers probed more deeply. We don't know how they would have handled that. We don't know what medical evidence they've presented in order to justify to the commissioners the accommodation. So it's really easy for them to say now after the fact that the accommodations worked. So anyway, that was that. That's not going to change. I'm not sure too many people will be happy about that. All right, so I'll jump right into the events of today. The first one I kind of expected would be not a very interesting foundational document presentation, but actually I think there's an important point that emerges from this, and it's about next of kin notification. And if there's one fatality, it's usually not all that complicated, and you can do these in an organized and timely manner. But when there's 20 plus, then it's different. People are living all over the place, and sometimes it's harder to find the next of kin. The other thing is to do it properly, because the Fatalities Investigations Act in Nova Scotia actually determines who the next of kin is. You think it's often a clear question, but not always. So the first next of kin would be your spouse or partner if you're cohabitating. If you're separated, that's not the case. Then if you don't have a spouse or you're not cohabitating, then it's your children, oldest to youngest. If you don't have children, it's your parents, oldest to youngest again. If you don't have children or parents, then it's your siblings next. Then it would be grandchildren, then grandparents, then aunts and uncles, and then nephews and nieces. In each one of those categories, again, it's oldest to youngest. Similar to the Intestate Succession Act, if you don't have a will and your estate needs to go to somebody, it's in that similar order, although the grandparents aren't included in the Intestate Succession Act order. So, we heard some of the evidence today from Ms. Hill about trying to get information, how difficult it was, that families weren't informed in a timely manner. Most families had to seek out information through the RCMP to get information, and they were trying however they could, calling employers, that worked at the jail, trying every channel they could to try to figure out information, getting things over social media. I know with Miss McCulley's case, the principal at her school posted on Facebook, so people saw it that way. Locals drove to the scenes, and there was some unfortunate incidents where people had guns pointed at them, or at least that's what they've said in their statements. So some really unfortunate situations there. Now, yes, it's hectic and everybody's doing every different thing and all that stuff, and especially during events as they were still unfolding, that's a difficult thing to organize. However, think of it this way. There's a separate policy for notifying civilians versus notifying RCMP members. With respect to Constable Heidi Stevenson, there was Constable Slater, Slawter, Slaughter maybe, and Assistant Commissioner Lee Bergerman, head RCMP officer in Nova Scotia, were at her house an hour and a half after she was killed to do the next of kin notification and start that process. Okay. It may seem like a relatively minor feature of all this, but think of it this way. It started everybody off on the wrong foot. It fostered suspicion, bad feelings, frustration right from the beginning. There's only one family that is not a participant in this inquiry, and there's only one family that's not suing the RCMP, and that's the family of Heidi Stevenson. So proper notification, respectfully done right away. Perhaps foreclose some of those thoughts or options in that family. So Had it been done right, RCMP may have saved themselves some difficulties, and certainly would have saved the families lots of heartaches. So that was the first part of the day, the presentation. Second part was Constable Nick Dorrington, really interesting witness. I'm from Guysborough. There's lots of Dorringtons down here in the Guysborough Sunnyvale area. It doesn't appear to be a relation. Here's something really strange, possibly very significant, probably completely meaningless, but it seemed like an unusual coincidence. Constable Dorrington was wearing the exact same tie as Commissioner MacDonald. I noticed this. Funny thing to notice, but sometimes, all right, so you're in court and a judge, if it's chambers, they don't always wear the robes. They come out and they'll wear a suit and tie. Always a very plain suit and tie, much like, what I'm having. I don't get too creative in my choices there. And most judges are the same way. Well, I noticed on the first day that Commissioner MacDonald had this nice tie. It's kind of an amoeba pattern on it. Well, Constable Nick Dorrington was wearing the exact same tie today, and so was Commissioner MacDonald. Now, if that was done intentionally, it's interesting. Maybe, I don't know what kind of a message it tries to send. Probably, if it's a coincidence, it is an amazing coincidence because it's an unusual tie. Anyway, I'd like to be interested to hear anybody's thoughts on that, and what kind of... Is Constable Dorrington trolling the commissioner? That seems unlikely. But anyway, that was something I noticed. Constable Dorrington, before joining the RCMP in 2015, spent 17 years in the armed forces, in the infantry. Looked like he saw some action. Struck me as a highly competent officer. He was talking about, some really interesting things on training, the IARD training. He said the training they received focused all on indoor events like schools, not outdoors. Didn't have night vision, didn't have this handheld, infrared sensing heat sensing device. Good advice on that. The handheld FLIR is what it was called. So if your regular members had that, you'd have no need to wait for the emergency response team to come in and take on the case. You can act right away in a serious situation. Constable Dorrington had worked all day. He had worked a 13-hour shift. He had gone home, had dinner, and he was ready to actually go to bed, but got a call and was up and gone in 5 minutes, ready to get back out there. Drove 200 kilometers an hour plus to get to the scene. He was asking about air support right away. But then he was relegated to sitting in containment. And I know he kind of bristled at this, and I don't blame him. It struck me as, say, if you had a top forward on your team, if you're the hockey team, and you got one of your best players, your best forward, and you see that you got a power play and a key moment in the game, and the coach sits him on the bench. Curious decision not to send him in there. He was very critical, Constable Dorrington, that is, of the decision not to send a second IR team in. He said the training they have is that you flood the area and get as many people in there as safely possible. And he felt it would have been safely possible to send at least one other team in. And it sounds like he would have liked to have been part of that team. Not only are you sitting one of your best players on the bench, but the players that are out there are using wooden sticks instead of composite ones. Without the proper gear in place to search for somebody in a wooded area in a rural community where the RCMP polices. So that was some interesting commentary there. He had some other recommendations later on about rotating lights, spotlights for the top of vehicles, and GPS capabilities, that sort of thing. So that was an interesting element of his testimony. He also talked about an earlier interaction he had with Wortman where he had stopped him. He was certainly aware of some media reports that suggested that it's unusual for an officer to be out at 6 p.m. in February pulling over speeders. He said, not everybody does, but I do. And he talked about that interaction with Wortman. Pulled him over for speeding, going 115 in a 70 or an 80 zone. Wortman turned into the Portapique Road, got out of the vehicle, which Dorrington says is very unusual. He's done thousands of these, and he said he'd count on two hands how many times people have gotten out of the vehicle. Wortman was infuriated, talked about how he had this interaction earlier with the Halifax Regional Police, felt he was being targeted. So the upshot of all that is that Constable Dorrington had a picture of him, and when he realized who it was able to distribute that photo around to some other officers. Again, though, the next morning, Constable Dorrington was talking to his wife, had some information from his wife was on the phone with somebody who was in Brookfield, saw this police car go by, seemed to be Wortman's car, and so Dorrington put it on the radio, and he felt that it wasn't treated as the top priority that it should have been. And then he had an unmarked vehicle. He was driving around and doing checking the Portapique community and just sort of driving around looking to see what else was out there and checking around. He felt he should have been involved in the action and the chase more, particularly because he had an unmarked vehicle. He thought that would have put him at an advantage, and he's probably right about that. He talked about the hit list as well, and we've heard about this potential hit list from Lisa Banfield's statement. It's not clear from that statement if an actual written list ever existed, or if it was just sort of a mental list that the killer may have had, if indeed that's accurate from Miss Banfield. Constable Dorrington had some choice words for Truro Police Chief McNeil and his criticism of the RCMP. You'll recall that Chief McNeil said there had to be a string of catastrophes in order for Wortman to have escaped the Portapique area and made his way down south through Truro. Dorrington says, well, let's see what he would have done with 10 or 12 officers. So he says they get along well at the constable level, operational level, but he didn't appreciate the comments from Chief McNeil. All right. So that was Constable Dorrington. Lots of interesting stuff from him, but those are some of the highlights. I want to talk about the videos that were released. And a curious thing, so I read the decision. They said that the videos were always available. Now, these videos have not been posted before, but the commission suggests that had anybody from the public wished to see them, they could have gone to the Mass Casualty Commission offices and simply asked to see them. Well, I don't think anybody knew that. So it's a little, it's a little rich to be claiming that at this point, that they were always available. The commission in their decision noted that their original... So they went through the legal test, and there's a lot of balancing of interests. You have to get the information out, but not put too much out there so that it would be sensationalized or traumatize anybody. And so they had made an original decision on the balancing of that, and now they're ready to revise their decision because nobody objected to it. Commission counsel didn't object to it, and nobody else did. Well, we know there was negotiations going on behind the scenes. Commission counsel initially did object to it, so did the federal government, but those objections went away, and that's what facilitated these videos. Now, I watched the videos. By the way, and there's a new process in the future for any evidence that may be withheld, not posted, that now the commission lawyers need to provide some reasons. They need to state the reasons, written reasons, and publish those along with where the exhibit would normally be. Us and the public will be able to see why that exhibit isn't posted. So we'll see how that works out if any further evidence of this nature is withheld. Now, the videos themselves, I watched the Pump 6 video, Pump 5 video. The Pump 4 video cuts out at the key moments, really. So anyway, you can see, you can see the shots fired. I don't think any adult is going to be, anybody that's watched action movies or anything like that is not going to be too traumatized by watching these things. They're not that difficult to see. A couple of things. I thought the video showed Constable Hubley did take a couple of, he took a second, looked a little bit back to his right, which I don't think you would do because the killer's vehicle is over to his left. When he got out of the vehicle, he kind of took a little turn back this way and then looked over, waited a beat, and then opened fire. So that seemed certainly consistent with Constable Hubley's testimony about his actions at that time. Another thing is, I don't think if you were planning to do it, if in fact you knew the killer was there and you were pulling up and you're like, well, I'm just going to end this now, I don't think he would have pulled up as far in the pump. So that was another thing I noticed. Well, I saw that before, of course, but it's more clear in the video. Pump 5, if you look at the video, it looks like Wortman might have got a shot away before he was killed. If you watch it just a second before the side windows and the windshield get blasted by the officers, you see something reaching down, a hand reaching down into the passenger seat, and then the car shakes. Now, it seems unlikely that just him shifting his weight in the driver's seat would have done that. I think that's a shot. So, looks like he tried to kill himself, or maybe did kill himself before he was shot by the officers, but we don't have quite that angle, so it's hard to say. Anyway, I just, the lesson from all of this is I don't think it was necessary at all for that video to be suppressed, and, here we are. So that's, the video is now released. There seems to be a better process in place going forward. The commissioners did express some low level of contrition, I guess, the reflection on their original decision, and they released it. So credit for that, I guess. All right, so that was it for today, day 38 of the proceedings. Some interesting decisions released, some interesting evidence presented, and we'll be back tomorrow with Constable Bent, who is the family liaison officer. So we'll see more of those original interactions with family members and representatives, and see what Constable Wayne Bent has to say. All right, so again, thanks for listening, thanks for watching, and we'll see you next time.